I think it's illustrative of what the situation is, what I in fact do in my office on a daily basis, and what my legal assistants are trained to do. And I'll tell you, here's pretty much like word for word what I say and what I have talked to my assistants, trained them, literally told them to say. People will call this is with a really legitimate case where every indication is that they've been outright cheated and that there may be a couple or $3,000 or something like that at issue. And that it's a totally legitimate case with a defendant from whom one ought to be able to collect. And I will say, I can't take your case. I don't have the time. I'm backlogged. I don't know of anybody to refer you to. I hate saying no. We get calls like this all the time. We say no all the time, and I absolutely hate it. And unless and until I clone a bunch of people to help me, I don't know what else I can do. And the horrible thing is, I can't tell you anybody else who will help you with this, because we know the attorneys that will do this kind of stuff, and we try to find somebody all the time, and I don't have anybody to recommend to you. And further, if you talk to the Attorney General or talk to any of the regulatory people, they won't do anything for you. Although I recommend you make complaints about this sort of thing. And it's an absolutely horrible situation, and there we are, and people get cheated all the time, and we can't help them, and I don't have anybody to say that can't help them. And that's a spiel that I've said in the past 5 years, many dozens of times, and it's absolutely horrible. And that's exactly the real situation. So that's illustrative of what's actually going on in the street for consumers in the great state of Missouri. The analysis goes about like this. Take a consumer case with, say, we'll say $800 worth of claims. Let's say a law or a series of laws have been flagrantly violated by a corporation that has money, and it would be collectible. And the claim for actual damages would be something on the order of $800. Now, if an attorney is going to represent somebody on a case like that, if there isn't a provision in the law for attorney's fees to be paid, well, there you have it. You have 3 hours worth of work by an attorney would eat up the $800. How can that conceivably be economically viable? It's not even, that's utterly laughable. So now we'll add in, let's assume it's a case with a fee-shifting statute where the court has discretion at least, may at least, award attorney's fees. Now, if an attorney is to take a case like that, and this is an analysis that I would walk through with any attorney that I'm talking to, in honesty to make sure that you're not misleading an attorney who might consider doing a consumer case, I'd say, well, okay, $800 in actual damages, what will it take for you to go through, win a trial, and prevail? How many hours will that take? Short of something so simple as like a signed promissory note, almost any case is going to have complexities to it. And with a big corporation defendant, they will have plenty of attorneys representing them, be fully and well represented. Even the simplest case, you're talking about many, many hours. Now, let's just say, let's pick a number and say you handle it in really simple fashion, but with able counsel on the other side and relatively simple facts. I'd be astonishing to get a case through even a simple trial that's not a jury trial, say, of a day, with less than 80 to 100 hours worth of work. Okay, a decent, competent attorney, minimum range of perhaps, say, $175 or $200 an hour. At $200 an hour, we're talking about, what's that, $16,000? Yeah, I think it's $16,000. And now, that's if you win. So the attorney's fees won't be paid unless you win. So if you don't win, then you don't get anything. Now, if the whole way that the attorney is going to be paid is by fee shifting, if the consumer can't pay, and a consumer with an $800 claim has no business being advised to risk $10,000, even if they have it, for attorney's fees, why, that's absurd. The only way you're going to be paid is by the fee shifting. If you win, if the defendant stays solvent, we've heard of corporations going out of business, and you don't get paid for how long? A year, median, 3 years, 5 years, and you have to advance costs. These things are That's an utterly absurd economic model. Any Wall Street business person would look at that and fall over himself laughing, saying, what kind of an idiot would attempt to run a business with a model like that? You can talk about the possibility of settlement. If the case settles in the first few months, well, if they pay, what, $800 plus now they're going to have to pay at that time, if you've got 10 hours worth of fees in, you're talking $2,000. So now you're going to ask them to pay that. Well, you can't bet on that, and any attorney, as a professional matter, who takes a case without being ready to follow it all the way through conclusion is being grossly irresponsible. So that's just not a viable economic model. If you start tossing in the potential for punitive damages, honestly, that's what's made it possible for me to be able to get anywhere with the consumer cases I've handled. Because when I represent somebody with a car that turns out to be two cars welded together when it's not supposed to be, and we have $15,000 worth of actual damages, we'll have a threat for punitive damages that may be 75, 100,000 or more. That is when it starts becoming economically viable. A settlement may be decent, and overall, if you're really good at what you do and you work really hard at it, you can make it work. It's not the best way to be paid. If an attorney wants to make a lot of money, it's still not the best. Far and away, if you want to make a good economic plan for handling cases, that's not what you do. It's a crummy way for an attorney to make money compared to the other ways that attorneys can make money with the same competence level, with the same ability to litigate. So that's kind of a thumbnail sketch, but the upshot is, especially if what you're really relying on is a fee-shifting statute in the court's discretion, if the court chooses to award fees, and you can only get them if you win, and then only at the end of the case after a long delay, and if the defendant stays solvent, and if your client hasn't died in the interim and things like that, then those are your fees. It's a totally laughable economic model.